Good afternoon, everybody. Welcome to the first in a series of complimentary webinars that Garfunkel Wild will be offering over the coming months. The webinars will cover a variety of compliance-related topics relevant to the healthcare community. Today's topic is how to handle Medicare and Medicaid overpayments. My name is Peter Hoffman. I am a partner director and co-chair of the compliance group at Garfunkel Wild in our Great Neck office. My partner, Jim Deering, based in our Albany office, and I will be presenting today's webinar. As we go along, I encourage you to submit any questions in the sidebar, and we'll do our best to answer as many as we can towards the end of the presentation. Jim's going to start the presentation today with a brief overview of the relevant laws applicable to Medicare and Medicaid overpayments, and then we'll walk you through the mechanics of how to actually consider and make overpayments. So let me turn the program over to Jim, and we can get started. Jim?
Great. Thank you, Peter. So let me get done. So putting the presentation in context, one of the main questions is what causes Medicare and Medicaid overpayments? And that can include a lot of things, including billing for services that are not adequately documented, using incorrect CPT codes, upcoding with CPT codes, billing for medically unnecessary services or for non-covered services, also payments received for services provided by unlicensed individuals or excluded individuals, and a whole list of things that are included on this slide, and more. So one of the big questions you're probably asking is, why do I need to return overpayments? The answer is simple. It's the law. It's the law under federal law as well as state law. And there can be significant consequences if the payments aren't made. They can include civil and criminal. So from the civil standpoint, they can include treble damages plus significant per claim penalties. That's under both the federal and state false claims acts. The federal OIG can impose civil monetary penalties. The New York State Medicaid program has its own sanctions. And also, individuals can be excluded from the federal health care programs, including Medicare and Medicaid. And from the criminal side of things, both federal and state law includes prohibitions that carry steep fines, as well as prison sentences. We'll provide more on this later. From the federal perspective, the Affordable Care Act, or the ACA, was established in 2010, and it includes requirements that overpayments must be reported and returned. The federal statute has the time period for that, which is the later of 60 days after the date on which overpayment was identified, or the date any corresponding cost report is due, if applicable. The ACA has three components that I'm going to discuss now. Components requiring reporting of overpayments, return of overpayments, and providing an explanation with regard to overpayments. Overpayments must be reported and returned to the appropriate party. So that can be the United States Department of Health and Human Services, the state of New York, or an intermediary. And of course, in connection with this reporting and return of funds, you want to make sure to send it to the correct address. Along with that reporting, you must also include a written explanation of the reason for the overpayment. As we mentioned, the ACA went into effect in 2010, but it wasn't until 2016 when CMS adopted a final rule adding specifics to when an overpayment is identified and when the 60-day reporting and return requirement starts to accrue. So this regulation only applies to providers who submit claims to Medicare Part A, which is hospital insurance, and Medicare Part B, which is medical insurance. Other rules exist with regard to Part C and D, which include Medicare Advantage and drug coverage. One thing that's important to note is that this rule does not apply to Medicaid. However, as we mentioned before, the ACA does apply to Medicaid. So until CMS fills the regulatory void with a rule specific to Medicaid, the rule we will discuss should be followed in those circumstances as well. So one of the key questions is, when is an overpayment identified? It is when the person has or should have, through the exercise of reasonable diligence, number one, determined that an overpayment has been received, and number two, has quantified the amount of the overpayment. Once that occurs, the 60-day period to report, return, and explain begins. A couple tips with regard to this: obviously you want to keep track of the dates to ensure timeliness. And also, one of the things we're going to get into in more detail is you want to act quickly or diligently. So acting with reasonable diligence is key, because if a person fails to do that, and in fact an overpayment is received, the 60-day time period may be considered to begin on the day the person received credible information of a potential overpayment. This is referred to as the should have requirement. So in other words, you should have acted diligently. So what constitutes reasonable diligence? The key bullet on this slide is the second one with regard to investigations. Investigations must be conducted in good faith, and they have to be conducted in a timely manner. And what that means is, at most, they need to be conducted within 6 months of receipt of the credible information. There is an exception for extraordinary circumstances. However, that's undefined, so you really want to do everything humanly possible to stay within the 6-month period. The investigation also has to be conducted by a qualified individual. The ACA look-back period is 6 years. What that means is you must report and return if you identify an overpayment within 6 years of the date the overpayment was received. As we previously referenced, there are a number of potential consequences for not returning overpayments. One of them on the federal side is the Federal Civil Monetary Penalties Law. Under this, the United States Department of Health and Human Services, Office of the Inspector General, the OIG, can impose monetary penalties on any person who knows of an overpayment and does not report and return the overpayment as required by the ACA. So for this, the OIG can impose a civil penalty of up to $20,000 for each item or service, and also assess treble damages 3 times the amount claimed. And there's also the possibility of exclusion from federal health care programs. As we mentioned, there are also potential criminal ramifications. Under federal law, criminal penalties are authorized when a person or entity has knowledge of the occurrence of any event affecting the right to payment, and they conceal or fail to disclose that event with a fraudulent intent to get payment, and that's either in a greater amount than is due or when no payment is due. The criminal penalties for this include a fine of up to $100,000 and imprisonment of up to 10 years, or both. Another tool on the part of the federal government is the Federal False Claims Act. It's referred to as the federal government's weapon of choice. They prefer to use this. The provisions have a number of prohibitions, including knowingly presenting or causing to be presented a false or fraudulent claim for payment, knowingly making or using a false record or statement, which is material to a false claim, and also knowingly concealing or avoiding or decreasing an obligation to pay the government. So let's talk about a few of the terms that are in here, terms such as knowingly, avoiding, and obligation. So what's it mean to satisfy the knowingly criteria? That means having actual knowledge or acting in deliberate ignorance of the truth or acting in reckless disregard of the truth. One thing that's important to note is that the False Claims Act does not require proof of a specific intent to defraud. One of the other terms we mentioned was obligation. An obligation is a duty arising from the retention of an overpayment after the deadline for reporting and returning it has passed. And finally, the word avoiding. Avoiding includes where an individual is put on notice of a potential issue, is legally obligated to address it, and does nothing. The consequences under the Federal False Claims Act include treble damages, that's 3 times the government's damages. Also, is more particularly set forth on the slide, current per claim penalties range from approximately $11,000 to $22,000. And again, providers who violate the Federal False Claims Act may also be excluded from participating in federal health care programs. Switching to New York state law, New York also has its own False Claims Act. That statute mirrors the Federal False Claims Act's prohibitions against retaining overpayments. These overpayments relate to funds received from the state or a local government. The state statute also provides for treble damages plus per claim penalties of $6,000 to $12,000. The New York State Medicaid program also has its own regulations and provisions relating to what constitutes unacceptable practice. An unacceptable practice under the state Medicaid program regulations constitutes having knowledge of any event affecting the right to payment and concealing or failing to disclose the event with the intention that payment be made when not due or in a greater amount than due. And so that carries with it its own penalties, which can include censure, conditional or limited participation in the program, exclusion from the Medicaid program, and or repayment of overpayments. In New York State, there are also mandatory compliance programs. They apply to certain providers who participate in Medicaid. They're required to develop and implement effective compliance programs. The entities that are subject to it are those who are subject to the Public Health Law, Article 28, which includes hospitals, nursing homes, diagnostic and treatment centers, as well as Public Health Law, Article 36, which is home care. It also includes providers who are subject to Mental Hygiene Law, Article 16, which is facilities, treatment facilities certified by the Office for People with Developmental Disabilities, as well as Mental Hygiene Law, Article 31, which includes facilities regulated by the State Office of Mental Health. In addition, others who provide care services or supplies under Medicaid or who submit claims on behalf of others and who reasonably expect to have at least $500,000 worth of billings to the Medicaid program in any consecutive 12-month period are also subject to the compliance program requirements. The compliance program must do a number of things, including address certain risk areas, obviously including billing and payments. It must also contain 8 specified elements, 2 of which include a system for routine identification of compliance risk areas specific to the provider, so it can't be a cookie-cutter program, and those things for self-evaluation, including internal audits, and as appropriate, external audits. Another requirement is that such systems must provide for responding to compliance issues, for investigating and correcting, for reporting to the State Health Department or to the Office of the Medicaid Inspector General, and for refunding of overpayments. There are other criminal statutes as well. Under the federal law, there are various healthcare fraud provisions. There are also federal criminal statutes dealing with theft or embezzlement in connection with healthcare. The same is the case under state law. The state statutes have additional healthcare fraud provisions, as well as larceny provisions, and there are various other state and federal laws that can apply. So now I'll turn the presentation back to Peter Hoffman, who will start with discussing recent enforcement actions.
Thank you, Jim. One of the issues we're frequently confronted with by clients is, well, there's a whole bunch of laws that Jim just talked about. There's FCA laws, administrative laws, civil monetary penalty laws, but does this really get enforced, and how often does it get enforced? And so before we get to the actual mechanics of different ways to make disclosures and some practical considerations, we thought that it would be useful to give you some recent examples of enforcement activity. So just last month, there was a hospital out in Iowa who paid nearly $2 million to settle violations or allegations that it violated the Federal False Claims Act for a number of years by improperly retaining Medicare overpayments in connection with inpatient claims that were billed, but should have been billed at a lower reimbursement rate, either the rate for outpatient services or the rate for observation services. And so that goes to retention of overpayment, which, as Jim suggested, is a violation of the Federal False Claims Act. That was just last month. Enforcement activity is not limited, of course, to hospitals. Back in October of last year, a Florida practice had to pay nearly $450,000, again, to resolve Federal False Claims Act violations. The allegations were that the group had allowed significant overpayments to accrue from a variety of federal health care programs, Medicare, Medicaid, TRICARE. They learned about at least $175,000 in overpayments no later than June 16, but they delayed and they delayed until the government got involved. And so the $175,000 in alleged overpayments turned into a nearly $450,000 settlement. And other providers, of course, are on the hook as well to follow these rules. One recent example, back in December of last year, a home health care agency in Massachusetts had to pay more than $14 million. The reason I wanted to point out this slide is a little bit different. The agency actually voluntarily disclosed that due to a misinterpretation of a state regulation, it actually collected these significant overpayments from the Medicaid program for unnecessary services. I think this was a good example to give because although the money was obviously quite significant, if you look at the last bullet point on this slide, because the company cooperated, because it self-disclosed, there was no additional monetary fines or penalties imposed upon them. It was a straight dollar-for-dollar payback with a little bit of assurance that they would do training on a going forward basis. So that's just 3 recent examples that we've seen in the last 4 to 6 months. And let's turn now to the mechanics. How do you go about returning overpayments that you have self-identified? The answer is there's a lot of different mechanisms to consider. And one of the things you'll want to do is look at the facts and circumstances of your particular case and decide which of these various mechanisms, or perhaps others, might be valuable. So let's start with Medicare. Jim talked about the Affordable Care Act's final rule from 2016. And that rule, in addition to laying out the timeframes and the penalties, says, look, there's a number of ways to deal with Medicare overpayments. First, the Medicare program has a reopening process available through the Medicare administrative contractors. That's limited to minor errors and omissions, and we'll talk about that in a little more detail in a moment. There's also the voluntary refund process for self-identified overpayments. Again, that's a process that is undertaken through the MACs. And there are self-disclosure protocols within the Department of Health and Human Services. 2 in particular. There's one for the Office of Inspector General, the OIG, has a self-disclosure protocol, which is used for potential violations of criminal, civil, administrative laws. And CMS has its own self-referral disclosure protocol that is used in connection with potential Stark law violations. The Medicare rule under the ACA also throws in kind of a blanket catch-all. There are other appropriate processes. Hospital credit balance reporting springs to mind that can be used. So you're not locked into these. You are locked into reporting, returning, and explaining, but there are different mechanisms that you can consider. As I mentioned, the first one is the Medicare reopening process. It's a limited process. It can only be used for minor clerical errors or omissions. What that means is mathematical mistakes, transposition of a procedure or diagnostic code, mistakes in data entry, wrong date of service, wrong provider number, computer errors, or other incorrect data items. The reopening process cannot be used to add additional services to a claim. That is the failure to bill for items or services. And it can't be used for third-party payer errors, the secondary payer process. So that's quite specific. Another thing to keep in mind is not every attempt to reopen is guaranteed. It's purely within the contractor's discretion. So if they decide, hey, really this is not a reopening, and they deny the reopening, you have no appeal rights. And finally, Jim alluded to timing, and it's something I'm going to keep coming back to through the balance of the presentation. Timing is an important thing. Under reopening, generally speaking, you can request a reopening within 1 year for any reason, or 4 years if there is good cause. And good cause is a defined term. So what are the mechanics? What's the process? Most of the callers on the phone today attending this webinar are from New York. I think we have some from Connecticut as well. The next few slides will be focusing on the reopening process for NGS, which is the Medicare administrative contractor, as you know, for both New York and Connecticut. There are 3 ways to do a reopening through the NGS system. One is electronically. They have an online portal called NGS Connects. A second way is paper forms in writing, the old-fashioned paper. One thing to note there is a variety of forms when you go on the NGS website, and they can be a bit confusing. First thing to look at is, are we dealing with a Part A issue or a Part B issue, because there are different forms. Part A has the clerical error / omission reopening request form, and no, I didn't name these forms myself. And if you're dealing with a Part B issue, it's simply called the reopening request form. On top of that, if you're dealing with multiple claims in a reopening context, 25 or more claims that present the same or similar situation, there's yet another form that you need to attach to the reopening form called the large various adjustment macro. And you see there on slide 31 certain specific examples of when that may be appropriate to use. There are certain modifiers, not every modifier, but certain modifiers or procedure codes, when you're changing them, may fall into this category. Changing the place of service, changing the quantity billed, those are all things that may be important to use the additional LVAM form. NGS, in terms of reopening, has a third option for Part B, which is their telephone reopening unit. And what that is you can simply call them up. Practice pointer, if you're going to go that route, you want to make sure you have all the information available. They're very particular about what they want. You can see here on the slide, you're going to want, some things are quite logical to think of: the beneficiary name, the Medicare beneficiary ID number, who you are, who the provider is, your PTAN number, your Medicare issued PTAN, date of service, reason for the request. And there are certain things that can be handled by telephone in terms of reopenings, and certain things that cannot. So we tried to give you a few examples as a takeaway. There are, again, certain modifiers that you could use this process for: adding or changing a diagnosis code or the rendering provider, changing the date of service, but needs to be within the same calendar year, adding a referring provider's name and NPI, and so on and so forth. Telephone reopenings are not allowed if you're talking about changing the year of service, in other words, going back too far, changing the billing provider, trying to reopen a refund request that has previously been made. You can't call up and say, well, I'd like to reopen that refund request I made. So that's a no-no. So that's one option, and as a practical matter, what you want to look at are these run-of-the-mill billing errors that don't seem to present a larger issue? Do they fit within the categories that allow for reopening, and are you within the proper time frame? If that's the case, the reopenings may be appropriate. And of course, as a compliance professional, one of the things we always suggest is you want to keep and maintain documentation that the refunds have been processed. If it's being done through the patient accounts office or the billing office, we typically suggest that the compliance officer be involved and at least get copies of those for your files. A second process that I think is a little more commonly used is voluntary refunds, which are when you self-identify overpayments. Again, this is a MAC process, and I'm focusing on NGS. NGS has a preference for the adjustment process. So if you can do it through the standard adjustment process and you feel that's the appropriate way to go, that's okay. If you can't, for any reason, do it that way, there are paper forms once again. And yes, once again, there are different forms for Part A or Part B. Part A providers have the Part A voluntary refund form available on NGS's website. You have the option when submitting that form to include or not include a check for the overpayment. If the check is not included, it goes through the standard Medicare processes where a demand letter will be issued to the provider. You can also fill out yet another form to select to have the overpayment offset, either over time or there is the possibility of asking for either a one-time immediate offset or a continuing immediate offset. If you're a Part B provider, similar process, different forms. There is the Overpayment Recovery Unit Voluntary Refund Form. That form is used when you're intending to submit a check with the overpayment form. And then there is the Overpayment Request Form, which, like the Part A form, goes back to the demand letter offsetting process. So the short answer there is, in using those forms, there's a lot of different variations. And to make sure your refund, your overpayment is properly returned, it's really important to take a look, make sure you're using the correct form, you're in the correct jurisdiction, you're sending it to the right location, and you're keeping copies. Common sense, but practical advice that we've seen some clients not always follow. So another question we're also asked is, well, why wouldn't I just, regardless of the issue, return the money directly to my Medicare contractor if you're dealing with a Medicare overpayment? And you can, but I think this slide really highlights why it's important to think those through and perhaps consult with professionals who deal with these issues on a regular basis. What the Medicare program says, and in fact it's on many, if not all, of the forms I've been referencing, is that just because you've submitted a refund to the contractor, that does not limit in any way the right of the federal government or any agencies to pursue appropriate criminal, civil, or administrative remedies relating to those claims. So in simple terms, that means you may submit a refund, but if there's some indicia of fraud there and there's a referral over to the Department of Justice or the OIG, and they want to bring a False Claims Act or, God forbid, a criminal action, the fact that you've returned the money to the contractor does not insulate you. So you'll really want to think about the right way to go there. Here are some tips. If you are considering the self-identified voluntary refund process to the contractor, when you take a look at the forms available on the website, you really need to gather all your claims information in terms of which claims you'll be refunding. They like to do a tick and tie. There are specific things that you'll want to have. Patient name, the HICN, date of service, the Medicare beneficiary identifier, claim number, and the amount of the refund. You also have to check off, it's a check-off box on these forms, a reason code. And that ties back to the ACA requirement that Jim was talking about, where you have to submit a written explanation. This will qualify as a written explanation. There's a variety of different boxes on these forms. Some of them are listed here: corrected date of service, corrected CPT code, changing, adding or removing a modifier, insufficient documentation, medical necessity issues. These are things that we see, and I'm sure everyone on the phone sees on a regular basis. And there are clear reason codes on these forms to check off. Now, many times we're confronted with overpayment issues where there are not just a few claims, but thousands or even tens of thousands of claims. It's just not practical to list every single claim. The government recognizes this, and you can do statistical sampling in connection with a voluntary refund. When you do, you need to explain it. You have to explain the reason for the overpayment, the methodology, and the formula used. And that, for those of us who are not experts in statistical sampling, can get quite complicated. As a practice pointer, we generally will consider in nearly every case, regardless of the mechanism, including an explanatory cover letter. What happened, why it happened, when and how we stopped it, and of course, the amount of the refund and the claim detail. It helps expedite the process, it helps present your good faith, and it helps ensure that you have a record going forward of your returning appropriately overpayments. Okay, so that's the Medicare process. We've talked about reopenings, we've talked about self-identified voluntary disclosures. On the federal side, you also have the OIG self-disclosure protocol. So when is that something you might consider? Well, the OIG has set forth a standard. It's pretty broad. And the eligible conduct under the SDP is that the disclosing party has made a reasonable assessment that the conduct at issue has potentially violated a criminal, civil, or administrative law for which the OIG is able to impose money penalties. That's a pretty broad standard. And as you can see, a lot of these mechanisms for returning overpayments can easily overlap. One of the differences with the OIG self-disclosure protocol is it's a much more formal process. First of all, you have to acknowledge in writing to the OIG that the conduct is a potential violation. Years ago, some lawyers, I won't mention names, would send a letter to the OIG saying something like, hey, you know, this issue has occurred. We think it probably isn't an issue, but you may disagree, so we're disclosing it to you. The OIG has put an end to that. They've said quite clearly, if you want to get into our protocol, you have to acknowledge the potential violation. You must explicitly identify the laws that are potentially involved. And in fact, there's a series of detailed submission requirements that are laid out in the protocol itself. And excuse me, once you make that submission, you have to wait to hear back from the government that you've been accepted into the protocol. So here are some specific examples of when you might consider using the protocol for the OIG as opposed to another mechanism. One, false claims to the federal health care program. Jim talked about the False Claims Act. If you have False Claims Act concerns that have resulted in overpayments from the Medicare program or other federal programs, the self-disclosure protocol should be on your list of consideration. Excluded persons, we see that all the time. Anti-kickback statute violations. One side note here, the protocol establishes a minimum settlement for kickback issues of $50,000. Generally, for anything else, there's a minimum of $10,000, although I will tell you that most settlements that we've seen with the OIG self-disclosure protocol do exceed those numbers, just by the nature of what type of violations generally end up in the protocol, as opposed to some other mechanism. Protocol is also open when you have a joint kickback and Stark violation. Although, and we'll mention this in a moment, if it's just a Stark violation, there's a separate protocol. Okay, so anytime there's a discussion with clients, they were like, why would I go to the OIG? They're a government investigatory agency. And the answer is there are real benefits to doing so. First, most providers, or many providers in New York, have mandatory compliance programs. The OIG views the participation in the self-disclosure process as an indicia of an effective compliance program, which is important. Second, there's a presumption against requiring a corporate integrity agreement. You go into the process, you work it through, you may not be saddled with a CIA. Third, there's a lower multiplier generally given when a settlement is reached on damages. The self-disclosure protocol typically will use a 1.5 times multiplier, whereas if you wait for the conduct to be discovered, if it's raised in a False Claims Act case, many times the damages, if it's settled, will be double damages as opposed to 1.5 times, and you'll get a CIA or be required to have a CIA. The disclosure through the protocol also stops the 60-day clock that Jim was referring to, which is, of course, a benefit. Here are some tips of things to consider if you're going down the route of the OIG protocol. You want to make sure that you've stopped the conduct. And that pretty much applies to any potential overpayment issue. One of the first things you want to do is stop the conduct, cut the liability, cut the quote-unquote bleeding. You want to make sure all necessary corrective action has been put in place. And the way to do that is to conduct a very thorough internal investigation, and we'll talk a little bit more about that in a few minutes. You got to go into this willing to work cooperatively with the OIG to resolve the liability. Unlike when you're in litigation, when you're in a False Claims Act litigation, anytime you're doing an overpayment, you should not be viewing it as an adversarial process. It's a collegial process. It's us coming forward and saying, hey, we have an issue. We got more money than we should. We're coming to you before you come to us, and we want to try to resolve it. And we found that when that approach is taken, you get the same approach back from the government. So it's a lot different than handling a litigation posture. We've given you a link there where you can get a little more information. We're trying to cover a lot today in a very short time. So there's a link at the bottom of page 40 that may be valuable to you. Fourth alternative with dealing with Medicare issues is if you have only a Stark issue, and I know that nearly everyone on the phone is familiar with Stark issues. CMS has a self-referral disclosure protocol that you can use to disclose potential violations of the Stark law. And again, the way you go about doing this is you need to make a good faith, reasonable assessment that there may be Stark violations. Here too, as of today, the look back period, that's a question again that we see all the time. How far do we have to go back? 6 years is the general rule for this type of violation. And the process is mostly electronic these days. The CMS has specific forms that they want you to submit through a portal. And once again, we've given you a link so you can take a look at some additional information. So that's the Medicare side. And remember, when you're dealing with federal healthcare programs, you do have Medicare, and of course, Medicaid is partially federally funded. So something like the OIG self-disclosure protocol can be used for Medicaid. But typically, if you have just a straight Medicaid issue, a Medicaid overpayment issue, you may want to look to the OMIG, the Office of the Medicaid Inspector General, has its own self-disclosure process. And again, we've given you a link to the website so you can take a look for yourself. They have some really crisp, clear directions on there. What type of issues would you report? Here are some examples. Billing errors, none of these will be surprising. Fraudulent behavior. Once again, employees are on the excluded provider list. That's quite common. We see that with some regularity. documentation errors that resulted in overpayments. And to be honest, what provider at some point doesn't have a documentation error that resulted in an overpayment? Other instances that are quite common, changing billing systems. That's quite common these days. Hospitals, ASCs, FQHCs, physician offices, changing their billing systems. That's a very time-intensive and complicated process. And often what happens is there are glitches, software glitches or something that may result in overpayment. So those are the types of examples that you would want to consider. Is the OMIG's SDP the right approach? There are also some things that you should not report to the Office of Medicaid Inspector General. One is if you're under investigation. Are you under a separate audit by the OMIG? Are you under audit by the DOJ, the OIG, the Attorney General's Medicaid Fraud Control Unit? If you're under an audit, you shouldn't just willy-nilly submit all the money back and hope that will resolve the issue. It won't. If, and I would assume you're working with an attorney if you're in that posture, if you discuss that with your attorney and you think it may be appropriate, you'll want to go to the investigative agency and say, hey, look, we want to return all or maybe some of this money, and then get their permission, then go through the process. The self-disclosure process for OMIG is also not appropriate for broader state-initiated rate adjustments, cost settlements, payment adjustments. They don't want you to put those types of issues through that process. And also, an important point that we see all the time. Way long ago, a decade or more ago, you used to be able to take an approach to say, well, we found all these overpayments, but we also found a whole bunch of underpayments, and we're going to net them out, and we're going to give you the difference. The OMIG is quite clear these days that you cannot net out your overpayments versus your underpayments through this process. If you were underpaid, you got to go through the EMEDNI, standard Medicaid billing requirements, and there are timely billing limitations, as you know, for the submission of claims. One note, something relatively new, the OMIG disclosure process is open to both fee-for-service and Medicaid managed care overpayments. So that's a good thing. It may streamline the process. Here's the process. They too have an electronic uplink form, which they prefer that you use, although you can also submit a letter with all the data claims. There's a very specific list, and we'll show you a slide on that in a moment as to what the claims information that OMIG requires constitutes. If you have a excluded provider issue where the excluded individual was paid through multiple sources, there's a separate form called the mixed payer calculation form that you'll want to be aware of. So here are some practical tips, practice pointers. Generally, we don't include a check for the overpayment when we submit it. Our overpayments, when we're working with clients, typically include the claims information and an explanatory cover letter. The OMIG does technically allow voids or adjusts, but they want that done prior to the self-disclosure. The reason they don't want you to submit a check is what OMIG will do upon receipt of the disclosure is review it and verify both the disclosure itself and the data, which they check against the Medicaid data warehouse. They tick and tie it because they want to make sure that if you're refunding certain claims, that those claims are annotated in Medicaid system. So if there's a future audit, it reduces the possibility that you may be audited on a claim that you've already returned the money for. Once that process is done, the OMIG folks will reach out to either you or your attorney and say we're good to go, or there may be some issues or questions they may have. Once those are all resolved, they'll send a final letter asking for repayment, and you will remit the payment, of course, unless there's been previous voids. There's also the possibility of a repayment agreement, and depending on the size and scope of your self-disclosure, if you want to repay over time, OMIG is willing to do that, often without interest. So that's a good thing. I won't spend too long on this slide, but if you want to go back and look at the exact elements of what OMIG expects in terms of the data fields for the claims constituting overpayments, there's a list right here on page 47. The next few pages actually is the OMIG's electronic portal form itself, so you have a sense of the type of information they're looking at. It's available on their website, but we thought it would be useful to have it here. That's the next 4 slides. And remember, there are other avenues of disclosure as well, generally depending on the seriousness of the conduct you're talking about. If it is severe enough, if it is potentially criminal, there are ways to go to the U.S. Department of Justice, the United States Attorney's Office. There are ways to go to the Attorney General's office here in New York, generally the Medicaid Fraud Control Unit, and they are amenable to disclosures as well. Okay, some practical considerations. How do you go about figuring all this out? There's a lot of different avenues. There's a lot of different rules. What do I do? Well, the first thing you want to do if someone brings to you an issue is do a thorough review or investigation. What's the issue? Who's involved? When did it begin? And one of the critical things you want to do is establish a starting point. That's fact specific, right? The issue that you're dealing with can be caused by any number of reasons. There may be a new regulation issue and for whatever reason, the provider was a little bit behind in adopting that. That could be through a reg, it could be through a Medicaid update, it could be through an LCD or an NCD on the Medicare side. Recently, we've seen a lot, and I alluded to this before, where there's a change in computer systems, and that can cause inadvertent glitches, but could lead to overpayments. There may be a new internal policy that was issued. And if all else fails, there are legal ways to look at cutting off the liability going back, statute of limitations periods under the False Claims Act or State Claims Act under the ACA. Oftentimes, you'll wind up with a 6-year look-back period, can be more in certain occasions. In your investigation, you're looking for the root cause. You want to keep your focus narrow to begin with. What we found is that people often stray. These are complicated issues. If someone brings to your attention a particular billing code, start by looking at that billing code. If it's an issue with a particular provider, keep your focus initially on that provider. That does not mean that if you come across other issues, you can ignore them. You may need to expand them. But remember, because you're dealing with timing limitations, you don't want to get caught in a morass of going in 10 different directions. And that's something we've seen time and time again. So try to keep your focus initially very narrow. And you'll want to understand the issues. Don't rely on, hey, my billing company said this was right or they're wrong. What are the rules? What are the guidance? What is the policy? You may need, God forbid, attorneys involved or regulators or consultants involved. When were they issued? How were they interpreted? Were they in effect during the period of time we're talking about? Key thing, key takeaway, if you identify there's an issue, one of the first things you want to do is put corrective action in place. What that does is it cuts the bleeding off. It stops the recurrence. It stops potential liability. And ways that you may be able to do that include, for instance, holding the billings, putting a new policy in place, doing training soon after that occurs, and in appropriate cases, considering employee discipline. Last thing you want to do, determine the overpayment. Define the effective time period. a start date, an end date, define the universe of paid claims, determine who's going to conduct the rule. They're quite complicated. Do you need an expert? Do you need a consultant? Are you going to look at every single claim, or are you going to try to extrapolate? It's generally preferable to do all claims. We know that that's often not possible from a practical perspective. The universe of claims may be thousands, and nobody has the resources to look at thousands of claims. So you can extrapolate, but you want to keep that in your consideration. And there are things to consider with regards to extrapolation, rat stats, whether you're going to retain an expert, whether you're going to put it under attorney-client privilege through a COVAL agreement or the like. And then make the disclosure, right? Who are the payers? Is this a routine error? Is there a violation of law? What are my options? What's the best choice? It's not an easy determination. We've made disclosures on behalf of clients to all the different agencies that we have talked about. So really, it's a case-by-case determination. But keep in mind that timing is key, particularly under the ACA. So in terms of your compliance program, have you returned overpayments? It is part of compliance. It is inevitable that mistakes will be found. The rules change frequently. And here's an interesting quote that we like that basically acknowledges the morass of Medicare and Medicaid regs. So every provider at some point has overpayments. And what you really need to do is not be afraid to be proactive. If you're proactive, that's going to be helpful. You'll want to prevent and correct your errors and violations, educate staff, return overpayments. Okay, so let's see if there's a couple of questions. We have a couple of minutes left that we might be able to answer. Let's see, hold on. So one of the questions that I think, and we're going to end at 1 o'clock promptly because we know everything is important. One of the questions that we got is which one to use. And I wish it were that simple. Really what you need to do is identify the issue. And you need to look at the scope of the issue, who was involved, was there something being directed with some form of knowledge that it's not in compliance with the law? Things like potential anti-kickback violations, paying for referrals, or Stark violations typically are not going to be handled through one of the lower level Medicare processes. Those are the places where you'll want to consider the self-disclosure processes either to the OIG or to CMS for Stark issues. Those are just very critical questions. One other question that comes up is how long do these things take to play out? They could take a long time, particularly if you go the OIG and SDP route or the Stark disclosure protocol, because those are complex issues. On the OMIG side, what we found is that things move quickly, provided that you have and are providing the right information. What I will say in conclusion that there should be less of a fear of using the self-disclosure protocols, be it to OIG or to OMIG. In our dealings with those agencies, we've found it to be a non-adversarial process. We found it to be beneficial in the long run to client. You can get, in appropriate cases, not just a release from the OIG, or you can also get a release from the DOJ. One last question is, will these slides be available? The answer is yes. We're going to send a thank you to all of you who participated in today's webinar. And in that thank you, we will, of course, send a link to or a copy of the materials. So what we're going to do now is conclude the webinar. We're going to thank you very much for your attendance. You also have our contact information on the last slide for both Jim and I, and we would welcome any questions that you may have. So once again, we thank you again. The next compliance webinar for GW will be June 21st, 2018, and that will deal with compliance issues. More information will be forthcoming. Thank you very much, and I hope everyone has a great weekend.